central jail, and then he's got some accident, and he fractured his chin, and they put implant on his teeth,
So,
and so he
put
couldn't
implant
eat
on his
anything.
teeth.
On his chin.
On his chin.
And he couldn't eat anything. We thought that he will be getting better, but then things are getting worse, and now he has some problem with his nerve as well. So if the case may be taken up today,
Okay.
as the last
Let us see.
deeply
We'll
obliged.
see.
For admission, item number 1.
My Lordship, if I may kindly be granted 3 weeks' time for obtaining instruction, ma'am.
Right, Mr. Zoram Chana.
See, my Lord.
See, Zoram Chana, the counsel for the respondents is granted 3 weeks' time to obtain instructions and file affidavit. This is the matter of the 3 weeks.
Deeply obliged.
Item number 2.
May it please, my lord. The SP Aizol had filed an affidavit on the 27th of August, my lord, wherein he has stated that the officer in charge, Sakordai Police Station, that all help will be provided to the petitioner,
What will be provided to the petitioner?
help and security in not leaving his village, my lord. He was asked to leave his village by the JSC, my. So the SP has made a statement to that effect, my lord.
So what remains?
Nothing
My
remains,
lord,
my lord.
there's an assurance on the part of the state to for the peaceful enjoyment of the land. However, my lord, the private respondents have filed their affidavit stating that certain reasons for their actions. And
Well, anyway, one thing is that we cannot allow, extra constitutional authorities,
Yes, my lord.
yes, my lord.
To act as they please. There's a law. There's a certain way to do things. We cannot allow vigilantism. You see, you cannot kick out somebody as you wish.
The JSC were summoned to the office of the SDPO also, my
Huh?
lord. The JSC were summoned to the office of the SDPO, Sakordai also, my lord. And they had made an undertaking in writing that they would not act.
It's like that story.
Against the law.
Let the person who has not sinned throw the first stone. All the villagers, all the JSC out there are sinless, pure as snow. Huh? Yes, you are appearing for whom?
Respondent number 6 to 8, my Lord.
That is the JSC.
Yes, and the respondent number 6 is the VCP Lungstum.
And 7 is the.
7 is the chairman of JSC.
And
8 is the secretary of JSC, my Lord.
Yes, you tell me.
Yes, my Lord.
Are they without any sin? They have never sinned in their life. Who are they?
They are the village people, my Lord.
I know, but can they act like this?
No, my Lord.
Then?
Yes, it's against the law, my Lord.
Huh?
It's against the law, my Lord.
Oh.
So they accept that. So they have they made an undertaking in writing before the SDPO, so not to act like this in the future.
You see, that if they act again like this, we will ensure that there is a criminal case against them.
My Lord.
And you see, you cannot threaten somebody or give him a diktat that he should leave the village. How much liquor did they find on him?
My Lord,
My Lord, that was not on record.
Nothing on record.
Nothing
No,
on
I am
record.
asking him, Mr. Counsel.
My apologies.
Sometimes you have got to let the others speak.
My Lord.
It's not your birthday every day. Yes.
my Lord, as per the JSC rules, which is created by the JSC on January of this year, so as per the rule number 2, so 1 lakh.
Is that rule enforceable in law?
No, my Lord.
Then can they do it as they wish just because of brute force? Totally unacceptable behavior. Totally unacceptable.
My lord, may I make only one submission? That the eviction agreement was signed on 15th of June 2024.
What
So,
agreement?
eviction agreement. So between the petitioner and the JSC.
Ah.
After that, my lord, 1st of July, so the petitioner was granted village house pass. So the VCP is also an ex officio committee member of the JSC. So that means there is no real intention to evict from our village. So since he has no
you see,
valid
there-
house pass, my lord.
No, you see, when he signed the agreement, do you think he had a choice not to sign? There is a thing in law called unequal bargaining power. When you have got 100 people wanting to kick you and slap you and hit you, it's a she, no?
He.
Do you think he can say no? Huh? If the entire village is against you, can you say no to whatever they ask you to sign? I don't think so. That agreement, I don't think is valid due to the unequal bargaining power. You see, an agreement is basically a consent given without any coercion or any mental, physical, or any other force being applied. I don't think he did it on his free will. Where is the agreement? Where is the agreement, Mr. Counsel?
Annex 3, it starts from page 21, my lord. The English translation is in 22.
And wait, it says here, given the option to choose his penalty. What is the penalty? One is to leave the village for a period of 2 years and prohibition of entry without so and so, so and so. And what is the second option?
A fine of 1 lakh.
Fine of 1 lakh.
Yes, my lord.
Why should this court not fine the JSC 1 lakh? Huh? Let the JSC pay 1 lakh for making such illegal laws. Who are they? Under what law can they make a penalty that someone should pay 1 lakh? When they don't have any power, why are they doing it by brute force? This is totally unacceptable. Maybe we should tell them to pay 2 lakhs as cost. This court can impose costs upon them. Do you know that? You please tell your JSC, if we ever get word again that they are doing such illegal type of acts, imposing penalty of 1 lakh, we will impose twice or thrice the amount. Plus, we will make sure that there is a FIR filed against them.
My lord.
This time we'll let it go, but next time we'll go as per the law. What they are doing is not as per the law. There is no village law like that. You cannot impose mob will or mob rule. Okay.
My lord.
You see, even as per the Village Council Act, a village court under the 1954 rules or 52 rules, Administration of Justice rules, the VC, as per the Village Council Act, the VC can only impose a penalty of 50 rupees. And who are the JSC? Under what law are they imposing 1 lakh? Tell them to strike down and cancel their laws. Penalty of 1 lakh. Show me their laws. Show me the law that they have made. I'll strike it down now. Show me their laws.
The rules is at page 25. That is the English translation, my lord.
Page 25 of your affidavit.
No, by the at WPC, my lord. Page 25 to 27.
Sale, possession of liquor, so and so is strictly prohibited. There is already a law, Mr. Counsel, enacted by the legislature. They cannot go beyond that. If any person is caught trading liquor 1 lakh and shall be overlooked for 2 years. Okay, right. Heard, Mr.
Lord Rokung Apautu.
Lal Roku Apautu, learned counsel for the petitioner. Also heard Mr. Samuel Valatia, the Champe, learned additional AG Mizoram. And Mr.
Yes, Valarriata.
S. Valatia, learned counsel for the respondents number 6 to 8.
6 to 8.
The grievance of the petitioner is that he has been made to sign an agreement dated 15/6/2024, by which the Joint Action Committee (JAC) of Lung Sum village, Aizawl district, has asked the petitioner to leave the village for a period of 2 years, with effect from 15/6/2024, as the petitioner was allegedly caught with liquor in his possession. The direction has been given to the petitioner in terms of the guidelines. Guideline number 2(B),
My lord.
2(B) of the rules made by the JAC. The learned counsel for the petitioner submits that the agreement dated 15/6/2024 has been signed by the petitioner under duress. He further submits that the petitioner had been given the option to either pay rupees 1 lakh for having allegedly been caught with liquor in his possession, or to leave the village for 2 years in terms of the rules made by the JAC. The petitioner's counsel submits that when there is a law promulgated by the Mizoram State Legislature prohibiting the sale, possession, and transportation, etc. of liquor within the state of Mizoram, in terms of the Mizoram Liquor bracket prohibition bracket close act, 2019, the JAC could not have made a rule which could not have made rules in violation of the MLTP Act. Full stop. He submits that even if a private person makes an arrest of a person for contravention of the provisions of the MLTP Act, the accused person has to be brought before the excise and narcotics or police officer under section 30 of the MLTP Act. However, in the present case, the JAC have their own rules, which is not in consonance with the MLTP Act. He further submits that the JAC do not have the competence or the power to frame rules for controlling MLTP Act, for controlling the sale, possession, and ownership and transportation of liquor in their village. He submits that the action of the respondents number 6, 7, and 8 amounts to mob rule and acting as an extra constitutional authority, by taking the law into their own hands. Next para, the petitioner's counsel submits that subsequent to the above events, submits that as the petitioner has come to this court, he has been continuing to live in the village as on date under the umbrella of the orders passed by this court. That's all? Anything else?
Nothing more, my lord.
So what have they said to you that you can stay? Have they said anything?
The only assurance we have is the affidavits filed by the state and the JSCs. Nothing more.
Okay, nothing more. Okay. Okay, right. The additional AG, by relying upon the affidavit filed by the SP Aizol, that is respondent number 4, submits that all help will be provided to the petitioner and he need not leave the village, in terms of the assurance given by the officer in charge, Sakordai police station. He further submits that an assistant sub-inspector of police and team from the Sakordai police station were deployed on 8/7/24 to prevent any untoward incident during the road rally organized by the JAC Lungsum and all NGOs of the village, in protest of the petitioner's non-compliance with the illegal agreement signed on 15/6/2024. He submits that the scooter of the petitioner that is rodeo scooter of the petitioner bearing registration number MZ056146, which was taken by the JC Lungsum on 14/6/24, has been returned to the petitioner on 12/8/24 by the JC Lungsum. He also submits that no act that an undertaking was made in writing by the JAC Lungsum, assuring that no action in violation of the rights of the petitioner and his family would be taken by the JAC Lungsum. Next para. Mr. What is your name?
S. Vanlalsheta.
S. Vanlashreta, appearing for the respondents number 6 to 8. Submits that as a YMA conference, general conference was to be held at Biate. Was to be held at Sakordai in 2025, steps were being taken for eradication of liquor and other contraband village articles from the village. In pursuant to the above objective, the JSC Lungsum was formed by the villagers for 1 year, that is from January 24 to December 24. And rules were made for obtaining the objectives. On 14/6/2024, some liquor packets were seized from the petitioner's scooter. The petitioner was accordingly given the option either to pay a fine of rupees 1 lakh or to leave the village for 2 years in terms of the rules made by the JAC. Yes, what is your submission?
At paragraph number 7, my lord.
The counsel for the respondent number 6 to 8 submits that the respondents number 6 to 8 never had the intention to evict the petitioner from the village, and this has been clearly substantiated by the issuance of land, by the allotment of land through a village council pass in the village council meeting dated 1/7/2024. Accordingly, the petitioner can live peacefully in the village on his own land. If there was any real intention to evict the petitioner from the village, the village council pass would not have been. Village council pass for a house would not have been. No, for a residence would not have been issued to the petitioner. He also submits that though the police should have been informed with regard to the seizure of the liquor from the petitioner, the Sakordai police station being about 12 kilometers away, it was difficult for the respondents to approach the police station. The counsel for the respondent submits that the petitioner can continue to live peacefully in the village. Respondents number 6 to 8 submits. Next, I have heard the counsel for the parties. A perusal, no, the perusal of the averments made in the pleadings of the parties and the submissions made by the counsels of the parties show that, not show that, they say, shows that the petitioner had been asked to pay rupees 1 lakh or leave the village for 2 years due to some packets of liquor being seized from the petitioner's scooter. The petitioner was accordingly made to sign an agreement dated 15/6. No. Dated, what is the date?
15/6.
56.
15/6,
15/6,
2024.
2024. Which was to the effect that he would leave the village from the night of 15/6/2024. What's that? This agreement letter signed by the petitioner can in no circumstances be considered to be a letter, to be an agreement signed by the petitioner on his own free will, inasmuch as the other option required the petitioner to pay rupees 1 lakh. So, the above being said, the Joint Action Committee of the said village, which has not been constituted under any statute and neither, what have I said? The above being said, the Joint Action Committee, bracket JC, is not an organization constituted under any statute, rule. Full stop. It is neither a registered body. As such, it is not a juristic person. Full stop. An extra constitutional authority imposing its will through sheer physical majority in numbers in violation of Article 21 of the Constitution of India. Cannot be allowed to function in the manner it has sought to do so in the present case. Full stop. Vigilantism and mob rule cannot be allowed to function in violation of the statutory laws of the country, statutory laws and the constitution of the country. The rules that the penalty sought to be imposed by the JSC as per the rules made by them regarding payment of rupees 1 lakh and eviction from the village are in complete violation of the Constitution and the MLTP Act. In the case of Union of India versus Tulsi Ram Patel, reported in so. Come on. The source of power must exist for exercise of the same. In the present case, not only does the JFC have no source of power to make such rules, to make such rules, penalties, but the JSC itself is a non-juristic person. This court is of the view that next part. No, don't say this court. The respondents number 6 to 8 have to act within the boundaries, within the four corners of the Constitution and the laws made under. And it cannot act on its own sweet will in violation of the prevailing laws. Next paragraph. The above being said, as the state respondents have guaranteed the protection of the petitioner while living in the village, while living in Lungsmoor village, and as the respondents number 6 to 8 have also made an undertaking in their affidavit that the petitioner can continue to live in the village, this court is at this stage not inclined to go any deeper into the issue. However, the respondents number 6 to 8 should keep in mind the fact that they have got no right to act beyond the laws framed by the legislature. Full stop. The legislature, the parliament and the legislature, and the state legislature. The above being said, now in view of the above reasons, this court finds that the writ petition has become infructuous. The writ petition is accordingly closed. With a direction to the respondents to ensure that the petitioner is allowed to live peacefully and he is not disturbed by the villagers of Lungsmoor village. Consequently, the agreement letter dated 15/6/2024 is hereby set aside as being unconstitutional and in violation of Article 14 of the Constitution. I will add some more. You see, there are judgments by Justice Chandrachud also with regard to vigilantism. So many, look, find out some judgments. Don't say, you see, when you say you're a lawyer, all your pleadings have to be backed up by the law. So please read some thing. Don't come directly to court and just say, my neighbor hit me or something. Give some citations. Yes.
Ghibli, sir.
Orders, item number 3.
Yes.
May it please, Your Lordship. My Lord, by way of filing this instant RFA, we are challenging the Heirship certificate number 1135 of 2020 issued to the respondent
What is the impugned order? Impugned order, date of the impugned order.
25/11/2020.
25/11/2020. Impugned order issued by
Court of the Senior Civil Judge, Aizawl, in Heirship case number
Heirship case number
yes, Your Lordship, come to that. 1135 of 2020.
1135/20. So, then when did you file this appeal?
This appeal has been filed belatedly after a period of 520 days.
When?
Yes, Your Lordship.
Which date?
Uh, 1st of November
2023.
3.
Now, as per the the re-COVID case
Right.
by the Supreme Court, how many period, what is the difference? Now, what is the period of limitation for filing an appeal?
90.
90 days. Now, the re-COVID orders passed by the Supreme Court, how many days can you subtract from this?
That would be for the period. I'll come to that. For the period from 15/3/2020,
To
15/3/2020 to 28 February 2022.
how many days is that?
That would be slightly under 2 years.
Say around 350 days.
It's roughly
There are 365 days, so 15 days
365
is
days,
that, so the
15 days.
350 days. So 350 days plus 90 days will make it 444 days.
right.
Now, what is the number of days between 25/11/20 and the date of filing of your appeal?
520 days.
520. 520 days minus 440 will come to 80 days.
Yes. But in the mean,
Of course, but altogether, so 520 minus 90 will be 430 days. How many days delay is there?
as per my calculation, after deducting all these days, my lord, it comes to about 45 days.
No. You mean after calculating that
After-
re-COVID days?
Uh-huh.
It comes to 45.
According to me.
It comes to 80 days.
So, in any event, Your Lordship, what happened was that this heirship was issued without any notice. I was not aware of it. So, I applied for another heirship certificate in respect of the same property,
Oh,
which was issued to me.
Okay. So there are two airships now.
So yes, thereafter, the respondent, they filed a review petition against my airship certificate saying that, look, there's already an airship certificate in existence in respect of the same property. That was registered as review petition number 18 of 2022.
No, you first give me his airship.
Yes.
His airship case is 1135.
113 of 2020, which was issued
1135 of 2020.
2020, issued on 25/11/2020.
And your airship was number
333 of 2021,
issued on
23 February 2021.
23 February 2021. Then his review
Review was filed
review case number
18 of
review
2022.
18 of 2022,
Yes.
and
It was
decided on
allowed via order dated 17/6/2022.
17/6/2022. Then what happened?
Then, my lord, due to a wrong advisor I received, instead of challenging his airship certificate, I filed a civil suit for a declaration that I am the owner of the LSC. This
Civil suit number.
77 of 2022.
Then what happened to this?
After that, after getting proper instructions from some other some other lawyers, I ultimately withdrew my civil suit via order dated 7/9/2023.
Then
Thereafter, I approached this honorable court on the 1st of November of 2023.
okay. So 7/9. When did you file the civil suit?
Civil suit was filed on the 1st of August 2022. That is after the review. Review was allowed
Okay.
in the month of
So
June.
So whatever it is, so this period between 1/8/22 and 7/9/23, I think section 14 of the Limitation Act can come into play. Correct?
My lord, in my
Do
opinion,
you know what is section 14 of the Limitation
yes,
Act?
yes, I know that.
So please read it.
It's an exclusion of time. So,
Huh?
section
Wait,
14,
wait.
yes, regarding the exclusion.
So you see, the issue is basically this. Let me see the order, your airship case number 25/11/2020. Where is that? Where is that order?
25.
Both of you. Where is that? In the main case.
Yes, you're in the main case.
In the main case.
His
yes,
airship
sir.
is at the first page itself, right after the index, the certified true copy.
So there was no notice issued.
No notice issue.
And who are you?
I am the son. She is the granddaughter.
Okay.
And
You are the son.
I am the sole surviving son.
You are the son of whom? Of whose property? Father's property, mother's property.
This particular property is the mother's property. Now, there are two.
Mother's name?
Mother's name is Lalnithangi.
Lalni Thangi.
Lalrin Thangi, sorry.
Lalrin Thangi.
She passed away on 30th of November, 30/11/2016.
And then, then how come, if you are the only son,
Yeah.
and this one is the grandchild, whose child is it?
She's the child of my youngest brother.
Okay, so how many brothers and sisters do you have?
We are 5 in. Your Lordship may kindly refer to page 4 of the appeal, memo of appeal. That facts of para 2.
Yes.
So, I'm the sole surviving son of Lalngaya and Lalrinthangi, whereas
So your name is Lalthamona.
yes, PC Lalthon, serial number 2. And the respondent's father is at serial number 5. He's the youngest son, no doubt.
Okay. So Lalmohanzwala is your father.
Yes, my lord. Yes, my lord.
Now you see, the only thing is that no notice was issued.
Yes, my lord, I know. My lord, if I may submit something, that the present application is not maintainable at all, because If I may take your lordship
No, no, I'm
to
not.
page number 8, the prayer portion. The initial prayer is not made regarding condoning delay of the appeal. It says that for
You're reading the appeal or the IA?
the IA,
IA.
yes. They sought for condoning the delay in filing review petition, not the appeal. Page number 8, that is the prayer portion.
May I reply to that, Your Lordship?
Just a minute. In filing a review petition
Yes, that appears to be a typographical mistake, my lord, on our part.
for review of the order dated 25.
The dates are otherwise correct. It's just that this should be
There should be
RFA.
a appeal
RFA.
petition,
My
appeal
lord.
petition for appeal of the order dated.
Yes, but then there is an order.
But
There's
then
a,
you have to correct it.
yes, correct, my lord. I understand. But there's a judgment of the apex court which clearly says that nomenclature will not come in the way provided the court anyways has the jurisdiction to
That is
entertain it.
different. That is different. This is different thing. That talks of when the court mistakenly mentions the provisions of a statute. This is not a provision of a statute.
My lord, no problem.
And you see, as per the latest notification issued by the High Court, now we cannot. All these things will have to be amended by way of an application. You amend it. That's the only thing.
Will just cause unnecessary delay.
But what to do?
But 151 is there.
No,
Your
no,
Lordship.
no,
CPC
no, no,
151
no.
is
Sorry,
there.
sorry. Please understand. We have got a lot of cases. The
Understood.
problem is now the CISF portal doesn't allow the correction like this, or our orders that we pass it doesn't become compatible with the pleadings. So all corrections that are to be made, there has to be by way of a application. I agree with you. It causes a lot of problem, but what to do? That is the law,
My lord.
and we have made the law.
True. I'll make the necessary changes.
Otherwise, the issue is simple.
My lord.
In fact, it has to be a condoned in a way, because Section 14 will come into play for this till 7/9/23 also.
My lord, I think they could not claim the benefit of Section
No,
14.
why?
Section 14, because the order, the challenge is heirship certificate. But
Maybe, but then they have gone. They have gone they have challenged it in a mistakenly by way of a civil suit.
no, they did not challenge any this heirship certificate.
No, whatever. They thought that the way to resolve the issue was to file a civil suit. Anyway, you see, in any event, when this court has passed enough orders that when there is going to be a grave miscarriage of justice, you have to allow condonation of delay application, because that is the judgment of the Supreme Court.
Yes.
That is in, what is that case? State of Nagaland.
Lipokau.
Lipokau.
2005.
And in Lipokau, they have referred to the emperor's case. And in emperor's case, it has been clearly stated. Anyway, you correct this question,
My lord, I'll do it.
Mr. Because this is a RFA also, not even a writ petition.
My lord.
And Mr. Lalfakoma, learned counsel for the applicant, says that submits that he will be filing an application to amend the IA, amend the prayer portion of the IA, as a typographical error has occurred therein. Accordingly, leave this matter after a week. You should have done it. I could have at least got one disclosure.
Item number 4.
Aman. May I please your lord?
Yes,
My lord, this is a 438 application, my lord.
yes.
And I was the search sheet has been filed, my lord, in this case, my lord,
Yes.
and the
Yes.
and my lord, in the search sheet, my lord, there is the only implication against me that there's a CDR report of a phone call of an arrested person with me, my lord. That is the only implications against me, my lord. And they've also admitted that the phone call also does not belong to me in the search sheet itself. With that implication, the search sheet has been laid, and I have filed the anticipatory bail, my lord, and the interim was granted, my lord. And accordingly, on the basis of the interim, I have appeared in the trial court, and in our trial has been proceeded under the law.
Yes.
Today, I am appearing in this case, my lord.
Yes. That's all. Yes.
So they are saying they like file an application, my lord, the last occasion.
You see, this is a NDPS
I
case.
think, my, yes, ma'am.
There are 2.5 kgs of heroin. Why don't
Yes,
you go?
it's not from my
Why don't you go for regular bail? Why don't you go to the court and ask?
on bail.
Because this is a NDPS case. This is not a simple other cases.
Actually, Lordship.
Yes, what is your case?
Actually, Lordship.
I've heard.
Number one, Lordship. First of all, I'd like to stress on one point that now the applicant has come before Lordship only under Section 428 of the
48.
483, 482, Lordship. As per
BNSS.
application, 482.
Okay, 482.
Of the
Achha, this is under 482.
And what I'd like to stress on here, Lordship, is that he has not come under Section 37 of the NDPS Act, which
No, there's no question of 37 because he's not been arrested.
but still it's bail, Lordship.
No, he's come for anticipatory bail.
Number one.
37 is bail, not thing.
But that, Lordship, I have some citations to rely on also.
Yes, give me.
And before that, my Lord. Now, in view of the strictures put on the commercial quantity of these NDPS items, Your Lordship, by Section 454, that is the presumption has been drawn, Your Lordship.
Yes.
Presumption has been drawn, and then unless and until the contrary is proved, they are presumed to be guilty, Lordship, since it's NDPS case, Lordship. So, if I may read Section 54 of the NDPS Act, Lordship, in trials under this Act, it may be presumed, unless and until the contrary is proved, that the accused has committed offence under this Act in respect of self.
Okay. Order. Yes.
Section.
Yes.
My Lord. Yes.
What does it say?
It says, the Lordship, that until and unless.
Section 54.
54. 54.
Presumed guilty.
Presumption is drawn, Lordship, number one. And that also, my Lord, as I submitted, in conjoint reading with Section 37 of the NDPS Act, my Lord, since that is bail, even if it's not released on bail, arrested, that will have to be taken into consideration, Lordship. And I'm sorry that I did not have time to place one recent citation, Lordship, made by the Supreme Court, my Lord.
What?
In
What
the
is the
case of
citation?
Hillary Tluang Asylum versus State of Meghalaya.
What does it say?
Section 37, Lordship, will have to come into play. Limitation. That is the importance is stressed on, my Lord.
No, Mr. Counsel, you're missing the bus.
Be that as it may, Lordship. Be that as it may. And I have, that is one ground, my Lord. And another one, Lordship. Now, if Lordship kindly go through the copy of the charge sheet, I think has already been conveyed to this record, Lordship.
Yes, tell me.
Record.
Yes. Yes.
In the charge sheet, Your Lordship, it is very clearly written the involvement of the present petitioner.
Yes, which page? Where?
Page Roman 8, Your Lordship. Roman 8 of that charge sheet.
What does it say?
It says, Your Lordship, the present petitioner is the one who contacted the driver, saying that this present petitioner is to be the receiver. And they keep on calling each other through phone.
Where in it? Where?
Para 18.
18.
In internal 18, Your Lordship.
Okay. That's someone under section 67.
My Lord, exactly. My Lord.
To
Then-
care also.
Yes. And he used this particular phone number through which he contacted the other accused person, driver, from whose possession that this article was recovered. My Lord. Keep on calling each other. And then his involvement is very much material and
Was any summons issued to him?
my Lord.
Where?
And someone, not only someone, Lordship. Standing warrant was arrested, Lordship. I mean, off arrest was issued, Lordship. Standing warrant is not.
Has he been declared absconder? And,
That, my Lord, that specific provision under section 82 till date has not been done and is in process, Lordship.
in process. Okay.
My Lord. So, for that, my Lord, he, if I may take Lordship to the prayer portion made in this charge sheet also at page Roman 13, Lordship. Further investigation in respect of this particular accused has been prayed for and allowed, Lordship. Further investigation into the involvement, even as he himself was very much known to be involved.
13 is a prayer.
My Lord, yes. That prayer has been made. Only, I'm saying, my Lord, that further investigation is also still going on in respect of this particular Parul, my Lord, Mr. Parul. And not only that, and if I may take Lordship to Roman 11, Lordship, paragraph internal 24.
Yes.
Evidences against suspected accused person, Parul. This is how he get involved in the present case, Lordship. Accused Masood Abdul Masjid Laskar has disclosed the name and mobile number of suspected accused receiver in his statement as Parul, which further corroborated during the investigation. So, and he used one phone number through which he contacted the person, the driver, in whose possession the SA was seized, Lordship. And he told him frankly that he was the person to be receiving that item at Silchar. And on receiving that item, he will be giving the Masood driver some amount of money, 50,000, Lordship. And all these transactions were there through phone. But before all this becomes completed, he on the way was intercepted by the police personnel. And the seized article was arrested. Seized, Lordship. And despite all this, Lordship, he avoided all contact and now has been absconding, Lordship. And the investigating officer also made every effort to contact him, and they even went to his residence, my Lord. And he somehow came to know that the police personnel were raiding his residence. He avoided and he got away, Lordship. Page Roman 10, Lordship, if I may take, Lordship. Page, paragraph number, internal 22, Lordship. Roman 10.
Yes.
Roman 10.
Yes.
That in spite of several attempts to locate, intercept, and arrest the suspected Parul Hussein Ahmed, he managed to elude the Drug Law Enforcement Agency. Also, the complainant
This
was
is the charge sheet or what?
charge sheet, Lordship. Charge sheet. This was submitted to the court, Lordship. So he avoid every kind of cooperation, interrogation also. So in these circumstances, the apex court has stated that anyone who is absconding is not entitled to any anticipatory bail. In the case of your Lordship, Lavesh versus State of Delhi, Lordship. Reported in 2012, 8 ACC 730, Lordship, at Barat 12.
Yes.
Barak 12. From these materials and information, it is clear that the present appellant was not available for interrogation and investigation and was declared as abscondent. Normally, when the accused is absconding and declared as so, there is no question of granting anticipated bail.
Has he been declared
Specific step we have not reached, Lordship. Is now in process, Lordship, because now it's very clear, even though that Section 82 has not been completed, Lordship. From the statement made in the charge sheet, it is very clear he completely absconded, Lordship, and avoided any contact with the investigating agency, Lordship. In that circumstance, he cannot be allowed bail at this stage, and he's not cooperating at all, Lordship.
That's all?
That's all, Lordship.
Yes.
My lord,
Yeah.
I'm sorry, my lord, I got disconnected, my lord.
Yes, no problem.
My lord, first of all, my lord, there's no material that any summon or warrant been issued against me, and it was served on me during the investigation, my. To
Yes.
that effect, my.
Yes.
In the search sheet, there's no mention that the summon or the warrant been served or any promulgation has been made in, or that I have avoided everything knowingly, my lord. That is not there in the charge sheet. And the next most important part is that as my learned friend has pointed out, to paragraph 18
Yes.
of the charge sheet, as well as, my lord, the allegations, my lord, paragraph 24, my lord,
Yes.
that it is my mobile phone. Now, Lordship, kindly turn to my petition, my lord, page 49. It is their document itself.
Page 49.
Page 49, it is their document
Yes.
that this mobile phone belongs to the serial number 4, my lord.
Yes.
Serial number 4 in the column, my lord, mobile phone number, which they have shown that to be mine. It belongs to one A. Lalmui Pui, my lord.
Yes.
So, there's no conversation has been recorded, my lord. Only there's a CPR report, my lord, between this mobile phone and the one person arrested already, my lord. The driver from whose possession, my lord, contraband allegedly recovered, my lord. Their only contention is that I am the person with this particular mobile phone, whereas this mobile phone also belongs to somebody else, my lord. So accordingly, they have filed the charge sheet without any summon or the warrant being served on me. So accordingly, I have approached this honorable court. The court has granted the interim protection. I have appeared before the trial court and submitted my bail bonds also. Then thereafter, the trial has proceeded. 2 witnesses has been examined. I am participated in all the proceedings till date. So there is no question of that I am not cooperating with the investigation, because that part is already been over, my lord. This trial has proceeded, my lord. Now it is in the evidence has been recorded.
2 witnesses examined.
Yes, my lord. 2 witnesses already examined. Day to day, I am appearing between the trial court, my lord. And the next date is fixed on 18, my lord.
18th of September.
Yes, and I have appeared on the last time on 4th September.
Yes, he said
So
he's
only
That is
material
only,
on the
Lordship,
mobile phone.
his appearance before the trial court is only after execution of the interim bail, Lordship. Before that, he avoided all contact, Lordship, even interrogation also, even to justify and explain how this particular phone number came to be used by him and was said to be used by that particular accused has not been explained to us also.
Have you interrogated him?
His Lordship?
Have you interrogated him?
No, my lord, not at all.
Why?
Because he is not available for that, my lord. He came to execute the bail bond only, Lordship. Only the bail bond. And only after that, he came to the court.
But they're saying that he participated in the.
I have
No,
appealed
my
for.
lord. No interrogation is there. As
No,
far
no,
as
in the trial, participated in the trial.
only one day, 2 days
Even
only.
that,
he
my
came,
lord,
my
4
lord.
days, I have appealed.
After that, after only interim protection is given to him only, my lord.
Anyway,
Before that,
Okay, let me hear the petition. Yes.
Yes, my lord. The 4 days, last 4 days only, there's a direction to me appear before the trial court, my lord. And accordingly, I have appeared before the trial court on interim on 4 occasion, my lord. Previously, my lord, there is no summon or warrant has been served on by the investigating authority for appearance, my appearance, my lord. I was in the dark, my lord, when the charge sheet has been filed. Thereafter, I came to know about this case, my lord. So I have approached this honorable court, and the only allegation in the charge sheet, my lord, is only the mobile phone. Apart from there is nothing against me, my lord. And that is apparent from their document is that mobile phone also does not belongs to me. It belongs to somebody else. And that person was not also been examined as per the section, their own material, my lord. Paragraph 18, my lord. And Mr. Lalun Pai, against whom this mobile phone is registered, my lord, he is not the accused yet. She is not been accused, my lord.
Anything else?
And I there's an additional affidavit, my lord. The trial judge also given some condition, my lord, in my additional affidavit, and I am complied with that also. That is, my lord, page 6 of my order of the trial court, my lord. Page 6 of the additional affidavit, my lord. After my appearance, my lord. There are 5 conditions has been given, and I am regularly following that, and I am appearing also, my lord. And I have given also local CVT as my bail bond. Page 8.
Anything else?
And if they are on the, my lord, further investigation still, my lord, they can always, my lord, interrogate me still. As my learned friend says, they are on further investigation of this case, my lord. So I'll appear, my lord, if the requirement is there, my lord.
Anything else besides that?
No, my lord. That's my lord.
Yes, Mr. Zoram Chana.
Your lordship,
They are saying that they will appear for interrogation.
a standing warrant was also reissued, Your lordship.
Reissued.
Reissued on 15/5 to 2024, lordship. 15/5. That may be, lordship, taken from the
No, reissued. You mean it was issued twice?
earlier issued, not executed and returned, and after that, on the prayer of the PP, lordship, it was reissued again on 15/5, lordship.
Okay, besides that, now they are saying that they will appear now for interrogation. What do you say to that?
No, my lord, they are not, even now, even after having their interim protection, my lord, have not become available for interrogation also, my lord.
There is no direction as such by the court, my lord.
No, my lord, direction is there. Standing warrant of arrest was already issued, my lord.
Trial is going on, my lord. I am on interim, my lord. Trial is going on. I have appeared in the trial court.
And
I have
as
processed witnesses, my lord. Where is that provision, my lord?
and
If the court directs me definitely in terms of the further investigation, I'll appear, my lord.
further investigation in terms of section 173 of the CRPC, my lord, was also allowed and prayed for and allowed, my lord. and that now is still continuing, my lord.
For what?
For further to
Further investigation
further
allowed.
for yes, my lord, to see the detailed involvement of this
Further
particular
investigation allowed as per?
as per 173
173A, my
CRPC,
lord.
lord.
So they apparently the search sheet which has been filed, my lord, it was not
And
the
for that
complete search sheet.
supplementary,
It was?
It was the not a complete search sheet, my lord. So as they have already admitted, my lord, it was the further investigation still going on. So definitely, I am on interim and the trial has already proceeded, and is still there on further
so
investigation.
actually it's premature,
So,
lord. Premature to be released on bail.
Just
My
a
lord,
minute,
when the
just a minute, just let me hear. So further investigation was allowed as per section 173?
My lord,
Huh?
8,
my lord.
8?
173,
178.
subsection 8.
170?
3
Eight.
subsection
3,
8. 173 8.
yes.
So the earlier charge sheet was not complete.
in respect of the present parole, my lord. In respect of the other one, it's okay, man. It's final and finalized. But now, since he is not available for interrogation and is not cooperating with investigation of the case, the present petitioner, lordship, we have to gather, collect
When was the earlier standing warrant of arrest issued?
that, my lord. Apologies, it was earlier than that, my lord. And as far as the record which is available here, my lord, is concerned, it says that since that earlier warrant was not executed and returned, so on prayer of the PP on 15/5, it was reissued.
That is why I'm saying, man, it was not executed and I was not aware.
Actually, right from the beginning, lordship, he absconded, avoided all contact with the investigating agency. That's a problem.
There's a procedure to be followed. There's a promulgation order can be hanged. Is it done?
That, my lord, as I've submitted. So, in terms of section 54, lordship, now since he is one of the accused person in the present case, and until and unless he can satisfy the court in respect of this section 54, and until his involvement is proven not guilty, lordship,
This K.
when he is not available,
This K. Lalmoipui, have you investigated her?
that also, my lord, is also going. If I may take lordship to the,
Because the petitioner is saying that she is the owner of the mobile.
my lord, not only these two persons, there may also be some other persons who are involved. my lord.
No,
And
but
for
then-
that, 173 was prayed.
No, but then the mobile is with K. Lalmoipui. Then how is this person involved?
That actually was used by this particular parole, my lord. And that,
Who
however,
said
was
that? Who said that?
charged it, lordship.
Where?
Charge sheet said that, man, without any evidence. And they are still investigating. Charge sheet is just an opinion. It has to be supported by some material, my lord.
Yes.
Where is that material that I am
Para
using
18,
in?
lordship. Para 18. Para 18.
Page?
Roman 8, my lord.
That is the same. That is the same paragraph he has shown to your lordship earlier.
They have not complied with. And for that, my lord, we have to take further investigation into even implicating all these persons in whose name this particular specific phone number has been registered, my lord. We have to, my lord, take on further investigation in terms of section 173 of the CRPC, lordship. And for that also, my lord, that prayer was made to the trial court and allowed, my lord. And not only this present petitioner, my lord, this other registered owner of the phone number will have to be included in the further investigation, madam. For that, I have made this, the IO have made this specific application, prayer before the trial court, madam. That,
The trial has already proceeded, my lord. Charge has been framed. Trial has proceeded. Witnesses has been examined, my lord. And they are still on the further investigation. There are so many. They are yet to verify who is the owner of the actual mobile
So,
phone, whether I'm
for
using.
that, my lord, until and
Let me
unless
come.
his innocence is proved, he is deemed to be,
It is not a case, my lord.
my lord, in terms of section
Only
54 of the NDPS Act, cannot be released on bail.
No.
Unless and
No,
until
no,
he satisfies the court that he is not guilty of the accused,
no,
my lord.
there is no such
Offense
absolute
alleged
bar, my lord.
against him, my lord. He is not in a position to be released on bail.
Okay, I think I've heard you.
Where is that bar?
I will,
Where is that bar, my lord?
okay. Anything else?
That's all, my lord. And
Where is
also,
that bar,
on
my
light
lord?
with my citation, my lord.
Huh?
My citation which I placed before
Okay.
you.
Okay, right. Heard Mr. Anshuman Bora, learned senior counsel, appearing for the applicant, assisted by Mr.
E.K. Boydya, Lordship.
DK Bhatta. Bhatta.
Boydya.
Okay, Baidya. AK. AK
DK.
Baidya. Yeah?
DK, my lord.
DK Baidya. BAIDYA. Huh? Also heard Mr. Sizoram Chana, learned counsel for the
NCB.
NCB. Hearing concluded, order reserved.
All right.
Item number 5.
This is from the, just from here. Just from here. Let's put it out there. Yes, so what is this case?
Your Lordship, this is a village council suspension case.
So you are appearing, who is the further respondents?
No one have appeared.
No one has appeared. What is your name, madam?
Simran Thapa.
Simran Thapa. Okay. What is your prayer?
Your Lordship, at the motion stage, we have prayed for an impleement of the Chakma Autonomous District Council, represented by the Executive Secretary of the Chakma Autonomous District Council, to be an array of respondent number 8, and the Secretary of the Government of Mizoram District Council in Minority Affairs to be an array of respondent number 9.
Okay. Why?
Because we have only included the elected officials and not the state.
Okay, right. Heard. What is your name again, madam?
Simran Thapa.
Heard Miss Simran Thapa, learned counsel for the applicant. There is one applicants who submits that the Chakma Autonomous District Council, represented by the Executive Secretary of the Chakma Autonomous District Council, should be implemented as respondent number 8, while the Secretary to the Government of Mizoram, District Council and Minority Affairs should be implemented as respondent number 9. Stop. No one appears on behalf of the respondents. On considering the prayer made by the applicant's counsel, this court is of the view that the application should be allowed. Accordingly, so and so are implemented as respondent number 8 and 9 respectively. The applicant shall submit a copy of the amended cause title to the registry of this court within how much? 2 years, 3 years, how much?
1 week will be okay.
Within 1 week. The I is accordingly allowed and disposed of. Then in the main case, you're right. In view of the order dated, just say heard Miss Simran Thapa, not counsel for the petitioners. In view of the order dated, and today is what date? 13/9/2024, passed in IAC number 159 of 2024. So and so have been implemented as respondents number 8 and 9. Issue notice to the respondents number 8 and 9. Who is for the state? State council is there. Just call them. Otherwise, we have to issue. We have to take steps. Then you just say, Miss So and So accepts notice on behalf of the respondent number 9. While now, full stop. The applicant shall take steps for service of notice upon. Has notice been issued earlier? No.
We have only served the notice to the respondent 1 to 7.
No, madam. This court has not issued notice till now.
Yes, Your
It
Lordship.
has issued. Correct. Issue notice, then petitioner shall take steps for service of notice upon the respondent number 8 by registered post with AD within a week. List this matter after 4 weeks. Before list the matter, you just write. In terms of the order dated 29/8/2024, petitioner was to take steps for service of notice upon the respondents number 1 to 7 by dusty mode to be routed through the registry of this court. Full stop. Thereafter, an affidavit was to be submitted by the petitioners. Full stop. However, the petitioners have not. No. Oh, it's been filed. Wait.
We have completed.
Full stop. This para. An affidavit dated 4/9/2024 has been submitted by the petitioner, which shows that no, this is not the way, madam. Your affidavit, you see, 3, 4, 5, and 6 and 7, they are all private respondents. You have served it upon the license officer of the CADC house. This is not the way. And then respondent number 1 is the CEM through executive secretary. You have served it upon the license officer CADC. Cannot be. You have got to serve it there to that person or to his PA, whatever. But to the private respondents, you have got to serve it upon them directly. You cannot do this. This manner you have adopted is not correct. Okay, what have I said? Full stop. No. An affidavit dated 4/9/2024 has been submitted, which states that notice has been served through dusty mode upon the respondents number 1 to 7. So, however, the notice has been however, a perusal of the notice served through dusty mode shows that all the notices have been served upon the license has been served upon one Mr. Amarendra Chakma, license officer, bracket administration, black close, CADC Rest House, Aizawl. The notice has not been served upon the concerned respondents in question. Full stop. Accordingly, the service of notice through dusty mode has not been complied with by the petitioners. You serve it through register AD, then better.
Yes, Your Lordship.
In view of the above, the petitioners' counsel submits that they may be allowed to serve the notices upon the respondents number 1 to 7 through the regular mode, also through registered post and with AD. The prayer of the petitioners' counsel is allowed. Petitioners to take steps for service of notice upon the respondents number 1 to 7 by registered post with AD within a week. This is the matter after 4 weeks.
Much obliged.
Supplementary list for orders, item number 6.
Acha, in that, madam, you'll be there in that case for the government, except notice in the one that I just passed the order. You just say, Mrs. Linda L. Rakha, I told you that. Respondent number 9, Ms. Linda L. Fumble, addition PP. Addition AG. Okay. Acha, Madam, Mrs. Simran, Papa, where is she? You please give copies of the affidavit to her. Okay. Yes, what is your case, madam?
My lord, this is bail application under section 439 read with section 37. My client is arrested by the excise personnel.
37,
Yes, my lord.
commercial quantity.
Yes, my lord. However, nothing was recovered from him except for currency notes.
Only currency notes.
Yes, my
So
lord.
how come 37?
It was seized from the other co-accused, and later on, from the light of interrogation, then the applicant is then again arrested. That, my lord, there is violation of section 42 as well. However, in the charge sheet, the time of seizure is stated as 9:15. 22, my lord, if I may take your lordship to the seizure and arrest memo.
Yes, which page?
Seizure and arrest memo. Page 21. My lord, the English translation is at
Page 21.
21A. That is the first seizure. My lord, if I may read.
Yes.
I, Rudlal Rodpui, ASI, Excise and Narcotics, do hereby seize below noted articles from possession of number 1, Manik Devnath, son of so-and-so, in Ramchandra Das, so-and-so. On this day, 22nd August 2023 at 3:45 a.m. at Simui, I also arrested the possessor at the same time and placed in presence of reliable civilian witnesses. The intimation of arrest is given to their relatives on the spot. That is there, my lord. And the second seizure is at
Manik
page...
Devnath. And what is your name?
My name is
Sanga.
Zonun Sanga. That, my lord, in the seizure and arrest witness, there is no signature of their relatives. It's not attested by their relatives.
Where? What page are you talking about?
The one that I was just reading at page 21.
21A.
21A is the English translation.
21, yes.
And 21B is the signature part. Only the accused receive the copy, and it was stated that intimation was given. However, it's not given, and the name.
So this thing was seized from these two persons, not from the petitioner.
Yes, my lord.
Then what is your second point?
My second point is the next arrest is at page 23, and the English translation is at page 23A.
Page 21. Page 23. Okay, how much have you seized out here?
24 lakhs 50,000.
This is money.
Yes, my lord. In the seizure and arrest memo, it's written at the time of seizure is written as 9:15 a.m. However, the actual seizure is at 3:45 a.m.
Page, where?
Page 23 is the time of seizure is 9:15 a.m. at
Where
Edenthal.
is it written? 9:15 a.m.
Page 23, my lord.
Where in
See,
23? First line, second line,
fifth
third
line,
line?
sixth line. On the left.
9:15 a.m. Yes.
Yes. However, my lord, in the seizure index,
At page.
at my lord, the seizure index is in the inventory photographs at page 42. My lord, in the picture, it might not be legible, but in the deposition of the seizing officer, in the cross-examination, she has stated that
Page.
page 42. That is the inventory photograph
Yes.
of the seizure index.
Where? Which line?
My lord, it's a picture. It's a photo. Page 48.
I cannot see.
Yes, my lord. If I may, in the deposition.
I'll need a magnifying glass.
Yes.
Right.
That is there, my lord. My lord, in her deposition, the seizing officer has stated that there is inconsistency at the time of seizure, which is at page 57. My lord, it's at page 57 and 58 also, but if I may read page 58, point number 8.
These are facts. These are issues that.
My lord, I have a point. These are facts, and if it seems the seizure was made at 3:45 a.m., then there ought to be.
What is this money? What is it? Is drug money? That's what they
It
say.
was alleged that it was drug money, but it is not, because they do not have any proof to suggest that it is sale proceeds
Yes, madam.
from the
How do you
contraband.
know it's drug money? How will you prove that it's drug money?
This is the first time it has come up. Let notice be issued at this stage, madam. We have just received a copy.
Yes.
This is under section
That is,
37.
section 37 says that we have to give a time to.
Yes, my lord. Yes, there are a lot of violations as well. Just saying.
No. What I'm saying is that I cannot decide the bail application.
Yes, my lord. Let notice be issued. My lord, we have some medical emergency as well. So if it may be taken as a fixed item on Monday, on Tuesday. Sorry, my lord. Monday is a holiday.
Monday or okay, right. Heard Mrs. Sakifana, Ms. Counsel for the petitioner, who submits that the seizure of the drugs in question in this case has been made on 22/8/2023. The petitioner has, however, been arrested on the ground that the money recovered from him was drug money. She submits that there is no proof that the money recovered from the petitioner is drug money. She also submits that as the petitioner is having some serious medical ailment, he needs to be released on bail. Mrs. Linda Elfambo, PP, submits that as the matter has come up for the first time, she may be given some time to go through the records. Praise aloud. This is the matter on Tuesday.
All right. Yes, oblige.
Hearing list, item number 3.
I don't think there is anyone. As no one appears for the parties, list the matter.
Item number 5.
In the next bench. Same, all. After a week, all of them after the week. Same order, huh? As no one appears for the party.
May I still your lordship intelligence on item number 7?
Okay, you're ready.
No, no, your lordship. I am appearing on behalf of my senior, Mr. Johnny L. Tochong, who has a personal difficulties.
Okay, in item 7, you say on the prayer for adjournment made on behalf of Mr. Johnny L. Tochong. This is the matter after the week.
And also, your lordship, may please item number 13 as well.
Okay, 7 and 13.
Yes, your lordship.
Okay, only 7, only 7. Okay.
Much obliged.